meeting of the Criminal Justice Council to order. Lacey, will you please take the roll for foreign purposes?
Hello, everyone. If you could please have your camera on for a roll and then turn your cameras after when I'm completed with it. Okay, Bill Sorrell,
As present.
Brian Searles,
Present.
Chris Flores,
Present.
Jim Whitcomb,
Present.
Glenn Boyd,
Present.
Wade Cochran, Chris Herrick,
Present.
Aaron Jacobson.
Present.
Tim Litters Dumont,
Present.
Susanna Davis,
Presente.
Mike O'Neill, Ben Herrick,
Present.
Kelly Price,
Present.
Mark Anderson,
Here.
Sadie Donovan,
Present.
Cassie Birdie Shaw,
Present.
and Scott LaValle.
Here.
See you.
And one more, Wade Cochran, one more time. All others present.
All right, and this is, of course, is the secondary testimony. The matter involving Sheriff Grismore. I believe where we left off 3 weeks ago or so. Defense intended to call a use of force expert. And I believe Mr. Capstone, whether witnesses available.
Yes. Our witness is Thomas Avini. He should be on the meeting. So, Mr. Avini, can you unmute yourself? And I don't know if there's a way that we can prioritize him for the meeting so we can all see him.
Yes, can you hear me?
Sorry, just Kelly, would you mind turning off your camera? And Tom Avini, if you could turn on your camera.
My camera's on. It's saying it can't start video on my end. Can you hear me?
Yes.
We can hear you, yes.
Okay.
The video on your end is not working.
I'm gonna shut down some applications. It's saying it's having difficulty with running video because I need to shut down some of my applications in the background.
Okay.
The fuck are you doing? What are you doing?
Could you, if you're not muted, could you please mute? Sorry, not you, Tom.
Mr. Avini, are you having any luck with your video?
I can see you. You can't see me?
We cannot see you.
Hmm.
We have him log out and log back in. Can you log back out and then log back into the meeting?
I imagine I can. Let me go to leave and I'll hit the link again. Okay.
Yeah, it looks like we have you back, Mr. Ravini, with a blank screen. Is there something covering your camera?
Well, my camera's on. I'm running my camera in an app in the background. Let me see if I can't close that. See if that doesn't cause any problems. Can you hear me now?
We can hear you fine.
I'm gonna leave again and sign back in again. I just closed the camera down. I had a separate camera app in the background.
Oh, there we go.
Oh.
Now we can see you.
Okay. Another app. Well,
Mr. Ravini, my name is Bill Sorrell. I'm the chair of the council and presiding over the proceeding today. And the first matter of business will be for you to be sworn in. So would you raise your right hand? You promise to tell the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
yes, sir, I do.
Thank you, Mr. Devlin. This is yours.
Thank you. Would you please say your name and spell your first and last names?
Thomas J. Middle initials Joseph for Joseph. Aveni, Aveni. That's spelled it as pronounced Aveni. Thomas Chomas.
Thank you. Where do you live, Mr. Ravini?
I'm sorry.
Where do you live?
I live in the sister state of New Hampshire, sir.
And what is your current employment?
I do consulting. I do expert witness work. It's a holdover. I've been doing this now for about 25 years, and it's an outgrowth of my police training background. But I also do work in the psych field. I've done my graduate work has been in forensic psychology, and I work with forensic patients at a psychiatric hospital.
Thank you. So in what areas do you provide services as an expert witness?
Use of force and all that entails, from deadly force down to soft empty hand control.
And is this in the area of police practices?
Correct, sir.
Thank you. And I have a defendant's exhibit D, which I shared with you earlier, which appears to be a CV for you. Can you take a look at exhibit D and confirm with us that this is your curriculum vitae?
I don't have it in front of me, sir. It's not in my list of my booklet of exhibits, but I did send you my most current CV, so I will stipulate that what you have in your hand is my CV.
Okay. Mr. Vini, I'd like to take you through your background in law enforcement. When did you first become a police officer?
1978,
And where was that?
New Jersey.
And in what states have you received certification as a police officer?
Well, starting out with New Jersey, and then I went to Utah, worked with the Utah Highway Patrol for a while. And then I moved to, I took a job with Smith & Wesson Academy as a police trainer. And I have had certifications also in the state of New Hampshire. I've resided in New Hampshire now for about 25 years.
And when did you first begin to provide any kind of expert advice or training in the area of police practices?
It wasn't a clean segue, sir. In the late 90s, about 1998, I started looking at so-called questionable police shootings. And that's when I got into clinical psych and then forensic psych, because I was trying to determine why different officers had different perspectives of the same event and what motivated one officer to shoot perhaps and others not. I started looking at a number of behavioral issues that underpin decision-making and the use of force. That really began in earnest like about 1998.
When was the first time that you actually did training of other police officers?
1983.
You say 1983?
Correct, sir.
Okay. And have you been recognized in any courts as an expert in the area of police practices?
State, yes, sir, state courts and federal court as well.
Thank you. And what is your connection to the Police Policy Study Council?
I was a co-founder and acting executive director.
And what is the Police Policy Studies Council?
Began as a think tank, primarily a multidisciplinary or interdisciplinary, I should say, think tank, and we set out to do behavioral research with NIJ grants, which were pretty hard to come by. We've done some research on grants, but NIJ money is a little bit hard to come by. That was our focus initially. Then we get into consulting.
And have you consulted on use of force cases?
That's primarily all I do, sir.
Okay. So at this point, I would ask that Mr. Rabini be recognized as an expert in the area of police practices. Thank you. So, Mr. Abini, have you had the opportunity to review the state of Vermont use of force policy that was in effect as of August 2021?
Yes, sir, I have.
Thank you. And have you reviewed other materials with respect to the matters involving Sheriff John Grismore?
I have in fact reviewed material sent to me, which I think is pretty complete.
Thank you. I would like to speak with you about Vermont's use of force policy as applicable in this matter. Do you have that available to you to review?
Yes, sir, I do.
So I would ask you if you could look at page 1 of 33 of this policy.
Okay.
And there's on the bottom, it speaks to, or right above where you'll see it says policy statement, there's an introduction.
Correct.
And this policy says nothing in this policy shall be construed to require officers to assume unreasonable risks in the performance of their duties. The safety of the officers and the public is paramount. Officers who fail to use timely and adequate force when it is necessary may endanger themselves, the community, and fellow officers. Can you provide any insight into this statement in the policy with respect to how that fits within police practices?
Well, it suggests to me that police have wide discretionary latitude with regard to what they can do, because we don't train police for every eventuality. It's virtually impossible. Nor do we train police in any and every manner in which they can use force, because we allow them some degree of improvisation depending on the facts and circumstances as they exist. And the Vermont policy, as I see it, is pretty, it affords quite a bit of latitude. When I see it holding officers to an imminent threat standard, that to me is pretty significant. So relatively recent development, I think. So we don't have to wait until we're actually physically assaulted. We can actually act preemptively to some degree, provided that we do so in a way that's objectively reasonable. So there are a few things that I see in the early stages of this policy that I find very conducive, or very conducive to what we have in this case.
All right, well, let me ask you specifically about the policy statement in this policy, which is on page 2 of 33 of the.
Okay.
I guess it's in except page 1, on the bottom of page 1 of 33. The policy says, when force is necessary to bring an event or incident under control, officers will use only objectively reasonable force to accomplish lawful objectives. What does that statement mean in the context of police practices?
Well, as Graham v. Connor detailed it, it's the perspective of the officer on the scene, that of a reasonable officer on the scene, if you will. And it's the term objective suggests to me that it's just that. So we might have 2 or 3 officers with slightly different perspectives, and what you generally learn when you're looking at within the realm of cognitive and perceptual psychology is there are no erroneous perceptions. They're just different perceptions depending on where we stand and what we view. So I see that embodied in this degree of the fact that we're holding officers to an objective standard.
So on page 3 of 33 of the policy, objectively reasonable was actually defined. And what the policy says about objectively reasonable is whether the decision by a law enforcement officer to use force was objectively reasonable shall be evaluated from the perspective of a reasonable officer in the same situation based on the totality of the circumstances. A law enforcement officer's failure to use feasible and reasonable alternatives to force shall be a consideration for whether its use was objectively reasonable. The calculus of reasonableness must allow for the fact that police officers are often forced to make split-second decisions about the amount of force that is necessary in a particular situation in circumstances that are tense, uncertain, dynamic, and rapidly evolving. Can you let us understand in the context of police practices what this objectively reasonable definition means?
Well, as I said previously, this is really boilerplate Graham v. Connor, and it affords the discretionary latitude, if you will, provided the officer's actions within the totality of circumstances, that the officer's actions be objectively reasonable. So we're forced to, and Graham v. Connor does warn that we can't hold officers to the standard of 20/20 hindsight. It actually cautions against that. So we're literally looking at or scrutinizing the officer's use of force within the confines of the scenario as he knew it at that time.
Is there any question in this policy whether the review of the officer's conduct is objective versus subjective?
In my mind, sir, I've had some background in internal investigation as well, and in my mind, it should be not only are the officers, the arresting officer's actions to be held to an objectively reasonable standard, but my feeling is that the manner in which he's judged should be objectively reasonable, or should be held to a similar standard in terms of looking at all the variables associated with the use of force in this case.
Well, let me ask you, in a case like this one, where there is a process to review an action by a police officer, what are the factors that are considered in the reasonable officer, objectively reasonable standard?
Well, anything and everything from the physicality or the physical wherewithal of the officer involved and that of the suspect who is resisting arrest, perhaps. We look at that equation, those variables in the equation, and then we go from there from prior acts that might be construed within this totality of circumstances. So we have prior knowledge of violent behavior, especially violent behavior toward other officers, perhaps. That can weigh very heavily in on an officer's actions with regard to reasonable expectations of what might follow. So this is pretty comprehensive when we look at this totality of circumstances standard.
Thank you. On page 6 of 33 of the Vermont use of force policy, it addresses the use of non-lethal force.
Okay.
The policy states, the dynamics of all encounters are unique. It is impossible to attempt to categorize or define the levels of force appropriate in any given situation or set of variables. When an officer determines that use of force is necessary and appropriate, the officers shall utilize objectively reasonable force. Officers should modulate their use of force as resistance changes. So would you help us understand from the perspective of police practices what this provision of the policy means?
Well, as I mentioned earlier, we can't train police for every possible eventuality. It's just not feasible. And this Vermont use of force policy seems to embrace that all encounters are unique and that we have to give the officer the discretionary latitude to handle these so-called unique encounters in a way that he thinks reasonable and necessary at that given time.
And what about this statement that officers should modulate their use of force as resistance changes? How is that understood in the police practices context?
Well, police are taught, or had been taught to some degree, escalation and de-escalation models that in the old days they used to be linear. Many are more circular now, but we're taught to diminish our use of force or de-escalate, if you will, depending on the level of resistance if it diminishes, and or increase what force we apply if it does not. If it instead of being modified or mitigated, if it actually increases, resistance increases, and concern for occupational safety increases, then we can actually use more force than we had previously. But it's supposed to follow again, it's supposed to be a reasonable progression, if you will.
Now, in a situation where the conduct of someone who police are controlling or attempting to gain control of gets more aggressive, what use of force are officers at that point expected to either increase or decrease as the person they're trying to get control of behavior worsens?
Well, that's an open-ended question. It really depends on the circumstances, but I'll give you a hypothetical. If I'm faced with somebody that's just offering somewhat passive resistance, that is, they're immobile, they just refuse to move, and I have to lift them, carry them to the back of a police car. So they're dead. It's dead weight resistance, passive resistance. And let's say that that increases at some point to kicking and headbutting, things of that nature, where we have active resistance. Then what would have been soft, empty hand control on the part of the officer then could probably elevate itself, reasonably be expected to elevate itself to a level of hard, empty hand control.
Okay. And in the Vermont policy on the top of page 7 of 33, there is policy statements with respect to individuals who resist police control. It reads, when a subject is non-compliant, response to resistance can be addressed by empty hand techniques, or in some circumstances, using tools designed to bring a situation under control. What is an empty hand technique?
Well, pressure point control would be an empty hand control, a soft empty hand control technique. There are any number of pain compliance techniques that are arm locks, any number of different types of come-alongs that would be soft empty hand control, as opposed to hard empty hand control, which are strikes. And even the term hard empty hand control is somewhat open-ended, simply because there might be occasions where we're literally fighting for our lives and we're kicking and we're doing things that are out of the ordinary.
Okay, so the next portion of this response to resistance policy is a subheading on page 7 of control/restraint, including soft empty-handed control techniques, that reads, officers may use a variety of techniques in accordance with their training to gain compliance with passively or actively resistant subjects, including but not limited to techniques using their hands, elbows, arms, legs, and bodies. From the point of view of police practices, what does this provision of the policy mean?
This is what some would refer to as a last resort within the realm of less than lethal force. This would be some agencies will literally embody or codify a last resort latitude in their policy, whereas you can do some things that you weren't trained to do as a last resort to assure occupational safety. And I would say that pretty much embodies what you've just read here, that this is, we're enabling the officer to do some things he might not have been trained to do because the circumstances warrant it.
Okay, and what does it mean? It says to gain compliance with passively or actively resistant subjects. What does that mean?
Pain compliance for actively or passively resisting?
What is actively versus passively resisting?
Well, again, passive resistance is generally referred to as dead weight resistance, where you just refuse to move. Let's say you're protesting at an abortion clinic and you get your arms interlocked and you're refusing to move. That's upon orders by police to move. That would be considered passive resistance or dead weight resistance. The moment we start getting any kind of physical action, where we actually rise to the level of elbows being thrown, kicking, struggling, things of that nature, then we categorize that as active resistance. If somebody's actually kicking or punching, some would refer to that as aggravated active resistance, but that threshold generally is the realm of something a little bit more serious. Generally, when we have weapons, we have aggravated active resistance.
And with respect to spitting by a person on a police officer, would that be considered active resistance, passive resistance, or active aggression?
My understanding of the way this is statutorily codified in the state of Vermont is that it's an assault, and as such, it would be active resistance.
And what difference does it make in the context of police practices if a perpetrator is perpetrating an active assault against a police officer?
Well, again, once occupational safety is at risk, then the techniques that we have at our disposal become much more profuse, where there are many more options we have on our menu. In this particular case, if spitting could entail soft empty hand control or some other method that actually, depending on the circumstances, we might actually see a pepper spray used or something else within that realm.
You mentioned at the beginning that you recognize, or in police practices, there's a distinction between imminent threat and immediate threat. Can you explain a little bit more about what that is?
Well, it's something that's evolved quite a bit over the last 20 years. An imminent threat is basically a reasonable belief that an assault is about to happen. It's a perception-driven, if you will, understanding of the actual context, the physical context, and behavioral cues that are exhibited by the subject that's being encountered. So it's an imminent threat isn't one that actually has to happen. It's just one that, if one reasonably believes it's about to happen, then it's actionable. And that to me is a pretty progressive aspect of Vermont's use of force policy. We don't have to wait to be assaulted to act preemptively.
Well, in the context of the Vermont use of force policy, is it weighted toward response to imminent threat or immediate threat?
It looks like it's weighted toward imminent threat. An immediate threat's been, some have referred to it as a dead man standard, that you're literally waiting for bullets, inbound bullets, before you can act. That's a pretty dramatic example of an immediate threat. Whereas an imminent threat is one in which if you see somebody reaching for a waistband, and when you encounter somebody suspicious of, who we suspect just committed an armed robbery, a further movement into a waistband might get somebody shot. That's a reaction to an imminent threat.
Would it be fair as an assessment under the Vermont policy to say that a police officer in Vermont is not required to wait to be assaulted to react against an assault that is reasonably believed to be imminent?
That's the way I read this, sir. And my understanding, and I've looked at this imminent versus immediate threat issue for probably about 25 years now, and it's because the verbiage you see in some case law will suggest that we have to wait for an immediate threat. Tennessee versus Garner is a good example, and that's 1985, so we've migrated quite a bit away from that since. But the Vermont standard seems to be one pretty solidly. Saw several references to an imminent threat standard.
Thank you. And let me turn now to a discussion of the Sheriff Grismore conduct specifically. In looking at the review of Sheriff Grismore's actions in this case, what are the factors that are significant as a police practices reviewer to understand about what information Sheriff Grismore had before he acted.
Well, prior knowledge of violence that occurred off-site, I think would have a direct bearing on an officer's expectations and precautions that he or she might take. And certainly his review of body cam video, of one of the deputies' body cam video is, I think, is relevant in this. It falls within the realm of totality of circumstances and his reasonable expectations, what might occur. Additionally, when he used this, what's been characterized as a foot push, and I'm perfectly comfortable with that description of it, because that's exactly what it was. What, it wasn't a kick. It wasn't a kick from a swiveling knee or a swiveling hip. It was literally a foot push. And that, given the circumstances, given the fact that spitting is almost always directed toward the face of the person that's being spat at, that foot push seemed like something that was done improvisationally, given the circumstances. And the initial push that we saw was relatively mild. And since that only had a transitory effect, the second one was a bit more emphatic. But until we had a spit hood on Burroughs, one could argue he wasn't fully restrained.
Thank you. You mentioned before that Sheriff Grismore had reviewed body camera video of Burroughs' behavior at the time he was arrested and transported to the police station. And in your review, that was important information that would inform a reasonable officer in Sheriff Grismore's shoes?
Yes, sir. I think that actually, and reasonably so, will influence an officer's expectations.
Thank you. So at this point, I have a new exhibit, Defendant's K, which is the police video that Officer Grismore observed. I would like to admit that and show it for the witness now.
Makes more sense to show it and then go to submission.
Okay, we can do it that way.
So I think. So let's start.
So for efficiency, we'll start at 14 minutes, 30 seconds on the video.
Everyone can see.
we're stopping here at 19 minutes, 18 seconds. And I'd like to ask Mr. Beatty some questions about this. So, Mr. Ravini, in this video that Sheriff Grismore had watched, we see a handcuffed Mr. Burrows attempt to kick one of the sheriff's deputies. What impact does that have on a reasonable officer in Sheriff Grismore's shoes at the time of the foot push incident?
Well, as I mentioned or suggested earlier, prior behavior influences our expectations. And his knowledge of that prior behavior should raise his level of concern to the point where he was more vigilant and perhaps more on guard for being kicked. Now, once we have him in leg irons, again, it's a matter of what we haven't taken away from him. So we haven't taken away spitting, we haven't taken away headbutting, we haven't taken away. And to be honest with you, there are documented cases where completely handcuffed people have disarmed police and shot them with their own gun. I mean, it's not common, but it has happened. So even the notion that somebody that's been restrained is benign, is no longer a threat, doesn't necessarily carry water with me.
Thank you. So you were present to listen to Deputy Major testify on the first day of the hearing, weren't you?
Yes, sir.
And one of the pieces of information that came out from Deputy Major that's included in his affidavit, which is Exhibit B in this case, that Mr. Burrows was banging his head against the plexiglass in the cruiser. How does that information affect a reasonable officer in Sheriff Grismore's shoes?
Well, again, we have to look at what expectations you might have regarding that behavior, a continuance of that behavior. So it's no longer within the realm of hypothetical. If the head is used as a battering ram, if the head is being used in that particular manner, then headbutting is certainly within the realm of possibility. The head could in fact be used as a weapon.
Okay. So apparently some of the council members were not able to hear the audio on the video.
I couldn't.
So I did. Were you able to hear it?
No, I was not. Just there was no sound.
Okay, so I think we should try that again. Yes.
Jeremy? Oh, knock his fucking head off.
Okay, take a seat for a moment, okay? Can I sit down?
Yeah.
Is it okay if I sit?
Yeah.
Okay.
I'll knock him out.
This is my partner. That's my partner. I need him to help me throughout the day, Jeremy.
I need help too.
Okay, so how can we help you?
I need help because I made mistakes in life
Okay.
and I've done bad things in life.
Okay. So Jeremy, right now, where we're at, we're here to help you right now. We're here to get you some services and get you some support. And for mom, it's feeling like that support isn't here right now.
Can you guys help me? I don't know.
Absolutely. So would you be willing to come with us and
Yeah,
talk
I
with
would.
someone from
I'd
crisis?
be willing, but I ain't no punk, bro. He wants to sit
Don't
there
put
running,
your fist
touch
in
me,
me.
I'll knock you out.
Don't do it.
I'll knock you out, bro.
Jeremy,
I'll knock you out.
no one's trying to arrest you or do anything.
I'll knock
today.
you out. I
But
guarantee
if
you, I give you 2 shots. Bang! Bang!
Carrie, wait! Now you can go to Carrie. Get out of here.
I didn't do it. I didn't do it. I was just saying. You did. I didn't. I was just saying. I didn't.
Stay back. Tell me to stay back. It's my fucking kid.
Exactly. Fuck
Tell him
him.
to stay back, please.
He did.
Let us get this settled and then we can talk, okay? I have nothing to say. He brought it on himself, but
All right, I can't lock those right now.
Okay. Jeremy, you got anything in your pockets? I don't. I got weed. That's it.
28 Central.
Okay. I'm gonna roll you to your side, okay? Okay, buddy. I got weed. All right.
Fuck off before I kill you.
Put one leg up. So we're gonna sit you on your butt.
Fuck off before I kill you.
We're gonna sit you on your butt. All right. Okay. All right. Can you go up to one knee?
Yeah, I can.
All right. Let's get you to a knee.
Okay.
Go ahead and stand up.
Hold on. Let me get to one fucking.
he's cooked on that.
He's, yeah.
Here, I'm gonna slide you over here, bud.
Look. Okay. Do not. Okay. Let's walk and be civil. Come on. Yeah.
Let's go.
Jeremy, wait! Stop! I guarantee I'll be locked out. I guarantee I'll be fucking. I guarantee I'll be fucking. I guarantee I'll be fucking out of. I guarantee I will be out of this shit within fucking not even 2 hours. Watch, motherfucker. Ow, that hurt. Okay,
All right, Jeremy, we're gonna keep walking forward.
Okay, I'm fucking pissed off, okay?
All right. Come on.
I hear you. We're gonna keep walking to the cruiser.
Fuck off. You guys just suck my dick. I guarantee I'm fuck off.
All we wanted to do, Jeremy, was talk.
Fuck off, okay?
Jeremy, keep walking. Jeremy, keep walking.
Jeremy,
What are you guys gonna do? Want to fight? Let's do it.
let's get in the car.
Check him.
Yeah. Jeremy.
In the car.
Let's do it, motherfucker.
Get in the car. No, come on. Here, let me just feed.
Wait, Jeremy.
In the car.
We're gonna turn you around.
Oh, fuck off.
Jeremy.
Come on, take him off. Watch me when I swing on you. I'm knocking you out.
I got his arm. You want to get that way?
What?
Help me.
Come on, Jeremy. Get in the car.
Fuck off.
Here, let me go around the other side. Jeremy, come on.
Fuck you. Fuck off.
Stop.
You wanna? I'll fuck you up. You wanna fight me one-on-one? You want one-on-one, nigger? Go ahead, motherfucker. I guarantee it. I'll fucking smash your face in, you fucking bitch.
You good?
Yep.
Mr. Reed, were you able to hear the audio that time?
Yes, sir.
Thank you. We were talking before about passive resistance, active aggression. Where does this behavior by Mr. Burrows fall on that spectrum?
At what juncture? From the very outset?
Yes, and to the extent it might have changed, where did it start? Where did it go?
Well, it got into active aggression fairly quickly. And what's important to note in this case is even after he was handcuffed, resistance didn't cease. So the notion that a handcuffed individual can't resist arrest, I think, is laid to rest with what we saw here. Their difficulty in trying to get him in the back of a police car. There was continued resistance to fully affect the arrest.
Okay. Now, I would like to turn your attention to the events surrounding Sheriff Grismore interacting directly with Mr. Burrows at the Sheriff's Department. And I know everyone's seen the video many times. If you feel it's necessary to look at it, we'll pull it up. Otherwise, I just want to ask you questions about that event from the police practices point of view.
Okay.
So on the video, we see Mr. Burrows stand up off the bench and fall face first onto his face. So what, from the police practices point of view, what sort of intervention is necessary in response to that occurrence?
Generally, you're restraining you're actually affixing someone's handcuffs to a pole or some type of an object is adjacent to the bench or chair that's being used for restraint. So the person can't get up. They can't do what he did. That was a pretty impressive face plant there. And that again kind of flies in the face of this notion that you can just merely walk away from a problem, because this guy without supervision was a continued problem.
And what we have observed multiple times on the video are the two deputies attempting to deal with Mr. Burrows, get him restrained more safely. From the police practices point of view, can you give us some insight into how the deputies were dealing with Mr. Burrows?
I think they were respectful. I think they were trying to use the least amount of force in controlling Mr. Burrows. But it looked like Mr. Burrows was not overly impressed or influenced by that.
And how effective would you rate the deputies' choice in gaining compliance over Mr. Burrows?
It's hard to second guess officers in doing what they did. When you're dealing with a drunk, you're dealing with someone who's extremely irrational, someone who's domestic disputes involving alcohol or drugs are one of the biggest challenges officers face on a continual basis. And so you don't know what's going to, de-escalation of a drunk is much more problematic than de-escalating someone who's sober. I mean, that's my Captain Obvious statement of the day. But so how these two relatively inexperienced deputies performed that given day, they looked like they leaned towards showing as much restraint as possible, but in the meantime, it didn't seem to have any kind of didn't seem to have any mitigating effect on Burrows' behavior.
And in the video, we see Deputy Andele, the female deputy, bringing her head close to Mr. Burrows while attempting to push him back on the bench. What kind of hazards at that point was Mr. Burrows presenting to these officers?
Well, again, his head's not restrained, and he's already shown a proclivity to use his head as a battering ram. So, I mean, that possibility's there. That really can't be discounted. The spitting issue, again, is another issue. It's got a little bit more range, so even if you step back 2 or 3 feet, you're still within range of that. So, I mean, there are any number of considerations embodied in this that I think had to be considered on a continual. It had continually reassessed what they were encountering, and so with each attempt to get up off the bench and move, that required another counter move by the officers involved.
One of the opinions offered by the council's expert, Mr. Daigle, was that these deputies had essentially all the time in the world to deal with Mr. Burrows. What is your opinion about there being all the time in the world to deal with this individual?
My understanding, and it certainly comes from years of experience with a small understaffed agency, is when you're processing somebody, you're trying to get them processed as quickly and as efficiently as possible. That includes safety. because you've got other calls pending, you got people on the street that are perhaps working without backup, that sort of thing. So there's really not, it's not like there's an unlimited amount of time to process an arrest. Additionally, the fact that when they did walk away from him, again, we have that other consideration. This guy was a menace to himself as he tried to walk away from that bench. And I'm really amazed that he didn't seriously injure himself when he fell flat on his face. There's really nothing to break his fall but his nose, and it was. I'm surprised he didn't have any serious injury.
And the council's expert, Mr. Daigle, referred to Sheriff Grismore's intervention with his foot as a foot push. What is your opinion about Sheriff Grismore's use of his foot with respect to Mr. Burroughs?
Given the circumstances as I see them, and as he apparently knew them at that time, I thought the foot push was actually objectively reasonable.
And there's a foot push at first where Mr. Burroughs gets seated back on the bench. Mr. Burroughs gets back up, and then Sheriff Grismore uses his foot as a second time. Can you, in your opinion, is there any distinction between the two incidents in which Sheriff Grismore used his foot to put Mr. Burroughs back on the bench?
The second foot push was actually, I think, a little bit more emphatic. And this is a value judgment now, but I'm always looking at behavior and how to modify aberrant behavior. And what I saw was a modification of Burroughs' behavior after that second foot push. It was emphatic enough to bring about the desired result. That seemed to be the end of the problem.
What about the second foot push being in response to or anticipation of some conduct by Mr. Burroughs?
The second foot push seemed to be in anticipation of something imminent. That being, it looked like he was perhaps, at least from the officer's perspective, was preparing to spit again.
And are police officers in Vermont, and in your point of view from police practices and understanding the Vermont statutory scheme, are they required to endure being spit upon without taking action to prevent that from happening?
Unless there's a more definitive stipulation, from what I see, it's an assault, and therefore it can be treated as if it were an assault. Generically, your reaction to an assault, again, still has to be objectively reasonable, but we can take it, if we see it as an imminent threat, we can actually take reasonable actions to try to interdict that threat.
One of the opinions offered by the council's expert, Mr. Daigle, was that defense of others is not a consideration in use of force. What is your reaction to that opinion by Mr. Daigle?
With all due respect to the gentleman, because he's extremely adept at what he does, that runs contrary to everything I've ever learned in criminal justice and or police training, and that we have an obligation, we're duty bound to protect third parties. That's something that the general public carrying a concealed weapon, you really have no obligation to protect third parties if you're if you're acting in self-defense. Police officers have an obligation, and that's been taught for as long as I can remember, going back into the 70s, that you have an obligation to protect third parties. And if the third parties happen to be other officers, then so be it.
And so, turning back to the interaction between Sheriff Grismore and Mr. Burroughs, to the extent that Mr. Burroughs was creating or presenting a risk of harm to the deputies, and particularly Deputy Andalay, how would that impact into the reasonableness of Officer Grismore using his foot to push Mr. Burrows back on the bench?
That would weigh heavily on whether or not we would consider this, again, from the perspective that we're evaluating this. That to me would suggest that it was objectively reasonable.
And what is your opinion on whether Officer Grismore's use of his foot to push Mr. Burrows back on the bench was objectively reasonable or not?
The fact that behavior had not curtailed on the part of Burrows, the fact that he still seemed to have an assaultive mindset, the fact that he still seemed to want to resist, that I think some descriptions were given regarding the fact that he was fighting his handcuffs, as if he was trying to get out of his handcuffs. The second push was a little bit more emphatic, and again, it brought the desired result. That's the first time I saw Burrows exhibit any degree of modified behavior.
And so what is your opinion in this case about the objective reasonableness of Officer Grismore's conduct?
Again, I think it's well within the realm of what I see in Vermont policy here with regard to less lethal force. It was reasonable given the facts and circumstances as he knew them at that time. It appears reasonable given the facts and circumstances as I know them at this time. So I would say what he did was well within the realm of what I see codified here in Vermont policy.
Okay, thank you. Those are all the questions that I have.
Do you wish to move the admission of the exhibit?
Yes, we asked that Exhibit K be admitted. Thank you.
Mr. Beebe, can you hear me?
Yes, ma'am.
If at any point you have trouble hearing me, just let me know. I'm sitting a little further away from the device that captures the sound. My name is Kim McManus. I'm the prosecuting attorney today. I appreciate you coming and joining us this morning. I
My
have a
pleasure.
few questions first. My apologies. I have to remember there's a delay.
That's okay. It's just said my pleasure.
I have a few questions about your background, Mr. Beebe. You were a full-time police officer in New Jersey from 1978 to 1990, is that right?
That's correct.
And when did you go out to Utah?
I went out to Utah in '85 and returned to New Jersey in '86.
Okay, so Utah was a brief pause from New Jersey.
It was sandwiched in between my two separate stints in New Jersey, correct?
And then you said you worked at the Smith and Wesson Academy in Massachusetts, is that right?
That's correct.
And you were there for 11 years.
That's correct.
And at that time, did you maintain your certification in New Jersey?
I did not. I worked for a while. I worked in New Hampshire. I started working in New Hampshire as a part-time officer once I moved to New Hampshire.
What year was that?
That was 2000.
So there was 1 year of overlap when you were certified in New Hampshire and still working with Smith and Wesson in Massachusetts.
That's correct. I was working anywhere from 40 to 60 hours a month as a part-time officer in New Hampshire.
That was from 2000 until 2014.
That's correct.
You maintained your certification in New Hampshire?
Well, I did it until 2014. I'm sure it's lapsed by now.
Okay, so
Right, so you have not, there's not a, ability in New Hampshire to remain certified, if you're not actively working as a police officer.
Sure, there's an ability. There's no desire. I'm 70 years old now. I have no desire to do that anymore.
Okay, so you're last active as a police officer in 2014, correct?
That's correct, ma'am.
So currently you are not certified as a police officer in any state.
That's correct.
In your CV, Defense Exhibit D, you have a very long list of specialized training, specialized firearms and use of force training. It's about 4 pages, I believe. Does that sound right?
That's about right.
Except for your last 2 trainings, it appears that all of your training on that list was done from 2014 and earlier. Is that correct?
Yeah, the only thing I've been attending webinars as of the last few years, online webinars. I just had a recertification in a program, suicide prevention program. I just had a recertification in that, and I'm not sure if the CV reflects some of the latest training I've had, but mostly webinars. But that was a 40-hour recertification that I attended.
Was that webinar the legally justified, but was it avoidable course?
That's one of them, ma'am. Yes, ma'am.
On your CV, it looks like that occurred in December of 2022. Does that sound accurate?
That sounds correct.
Then it appears the one before that was in July of 2020, an excited delirium instructor course. Does that sound right?
That's correct.
And then the next course listed was July 14th, taser use of force.
Of 2014, you
That's
said? 2014, you said, ma'am?
Yes.
That sounds about right. I don't have my CV in front of me. That sounds about right.
Okay. So from the CV that you submitted to Attorney Kaplan, that he's admitted as an exhibit,
I'm not sure that that's.
That's a good point.
Oh, so I would move to admit Exhibit D.
And I would happily say yes.
Exhibit D is.
Thank you.
Apologies. So your CV that you handed in, it appears that in the last 9 years, you've taken 2 use of force trainings. Is that correct?
The last time I did what, ma'am? I'm sorry.
In the last 9 years, since 2014, you've taken 2 use of force trainings.
Well, again, there's some webinars that I've not posted because they're only like 3 or 4 hour webinars. I try to stay up on current issues, and the webinars really aren't what I would call formal training.
And I would agree. So formal training is what you've listed here in your CV. Yes?
Yes, ma'am.
Okay. So to clarify, in the last 9 years, you've only taken 2 formal trainings for use of force. Is that correct?
Again, I don't have my CV in front of me, ma'am, but that could be correct.
At one point in time, were you a use of force instructor?
Ma'am, I was a trainer of trainers, so that's probably a distinction we should make right from the outset. I trained trainers, and a lot of that was based on the research that I did. I published quite a bit of material on police shootings and on the behavior on the front end of decision making, all the things that affect behavior. So for me to attend other people's training is good. I'd like to see what other people have to say. But generally, what I've done over the last 23 years in particular is I've been a trainer of trainers.
And You're certified to do that, is that correct?
Yes, ma'am.
When were you last certified as a master use of force instructor?
It's a course that myself and another gentleman actually formulated from our own research. It's something that we structured and we taught nationwide.
So you certified yourself?
Yeah, you could say I certified myself, correct.
On your CV, it mentions that you were a master use of force instructor at the time that you were at Smith and Wesson Academy. Is that right?
That's correct.
And would that be sometime between 1990 and 2001?
That's correct, ma'am.
Have you maintained that certification since that time?
Well, I stopped teaching it after I left Smith & Wesson Academy. I started teaching something called Use of Force Management and another course, a 5-day program called Advanced Force and Control Instructor. So everything has been a college level geared towards management and use of force investigators primarily.
So currently, outside of creating your own course and certifying yourself as a trainer of trainers, are you certified by any other outside body, a national body for use of force instruction?
Well, again, you already read off the recertification I had a couple of years ago on excited delirium. So that's a certification. It's an outside certification. I'd have to look at my CV as to other outside certifications I've got or maintained, but I have sought outside certifications, whether they're in TASER or other aspects of use of force. I've had outside certifications.
Looking over your CV and doing a little research, reading your articles, it appears that you specialize in police shootings. Is that correct?
I specialize in police shootings, correct, and the decision making that goes into them.
And then deadly force management is an area that you specialize in.
What was that about deadly force management, ma'am?
That deadly force management is an area that you specialize in training.
That's one area, yes, ma'am. But I taught a more generic program called use of force management, as you already alluded to, and another program called Advanced Force and Control Instructor. That was a 5-day program.
I believe you mentioned on direct that you've done a considerable amount of research on deadly force studies. Is that right?
Yes, ma'am.
You actually did two, I think in your words, groundbreaking deadly force studies, two of the most groundbreaking studies ever undertaken. Is that right?
That's actually a description given by Force Science Institute of 2 studies I did, correct.
And that must have taken a considerable amount of time.
Yes, ma'am. One took the better part of a year, and the other one took probably at least 5 months.
And when were those studies done?
One was conducted in 2000, I think it was actually published in 2005, and the other one was published in 2008.
Again, that was focused on deadly force, correct?
Decision-making and the use of force in general, but deadly force in particular.
Did you write a draft report summarizing your analysis of this case?
That's all, that's what it was, ma'am, a draft report. It was not fully completed. There were some things I wanted to do that I didn't get the chance to do.
The draft report that I have states that you could change your opinion if you had some additional information, but otherwise that you certified that this was your opinion. Is that correct?
That's correct.
Since writing this draft in October of 2023, have you learned any additional information that would change your opinion that you've written in this report?
Some of the initial hearing that we had 2 weeks ago, some of the testimony given was, I think, elucidated some issues that I wasn't fully aware of, but that's the extent of it.
And the basis of your analysis in this report, you have a section called Foundation of Case Analysis. You mentioned your 26 years of police experience, correct?
Yes, ma'am.
You mentioned your experience as a police trainer, correct?
Yes, ma'am.
You had mentioned your exhaustive deadly force research that you conducted, correct?
Correct.
And you mentioned your current and past academic studies in human cognitive function, correct?
That's correct.
And then you mentioned and the evidentiary material that you were provided. Is that right?
That's correct.
In the basis of your analysis, you do not mention reviewing the Vermont statewide use of force policy. Is that right?
I have that here, ma'am. I've actually gone through that in great detail. That was an oversight in terms of what I provided in my that one supplemental page.
So at the time that you drafted this report, you had reviewed the use of force policy, Vermont's use of force policy.
I believe I had, ma'am. I believe I had because I had everything highlighted, pretty heavily highlighted.
You just did not put that in how you analyze a case. In the foundation of case analysis, you do not mention Graham v. Connor, the seminal use of force case law. Is that correct?
I didn't get into the one of the things I left out. If you look at the table of contents, I was going to do a review of Mr. Daigle's work, and so if you look at the table of contents, you'll notice that's one aspect that was listed in the table of contents, but was never completed, and that's where I was going to do a review of existing policy with regard to Mr. Daigle's report. So I never got that far. I had it, I reviewed it, I hadn't got that far in a report. I generally don't work in a way that where I'm asked to rebut the work of an attorney. But Mr. Daigle's kind of a hybrid here because he's both an attorney and he's I'm going to characterize him as a former police officer, but also a trainer. And so this is the kind of thing where any rebuttal I do would certainly not have been on legal grounds.
Okay. So only on factual grounds, not arguing the law.
Factual and the actual policy that I was provided, the Vermont policy.
Okay. In your, one moment, In reviewing an officer's use of force, we look at the totality of the circumstances. Is that right?
That's correct.
And that term means the facts and circumstances of that particular event, correct?
Yes, ma'am.
And that includes the officer's perspective of the event. That's correct.
Primarily, yes, ma'am.
And it also includes any other facts known to the law enforcement officer at that time. Is that right?
Yes, ma'am.
In your draft report, you provide an incident summary. Is this summary your facts and circumstances that you based your opinion on?
Is something in particular you're looking for, ma'am?
Only there's a 6-7 page incident summary. And I'm wondering if this summary is your facts and circumstances that you pulled together. That's the basis of your opinion.
Okay. Can you cite the page for me then real quick?
It starts on page 3.
Page 10, I think.
Incident summary.
Okay, I thought you were on page 10, use of force reasonableness based upon. I thought that's what you're looking for. Where are you at, ma'am?
Nope, we'll get there. Page 3 through 9. It says incident summary. Essentially the summary of the event.
Okay. And I used,
Are those
go ahead.
the facts and circumstances that you based your opinion on?
Yes, ma'am. His perspective of events as they transpired. Yes, ma'am.
Okay. So in your incident summary, you only included Sheriff Grismore's perspective of the events. Is that correct?
That's my understanding of what actually matters most. Again, my behavioral research has been focused almost exclusively on what drives an officer's decision making, and so I'm not here to question what the other 2 deputies did or didn't do. I focus squarely upon Mr. Grismore's actions.
And the perspective that you took of then Captain Grismore was his account that he gave the internal affairs interview. Is that correct?
Yes, ma'am.
And that was a 6-page type statement that he handed into the Vermont State Police before his interview, correct?
I believe so. Yes, ma'am.
Your narrative summary does not include any of the questions that Detective Trottier had for Mr. Grismore after reviewing that statement. Is that correct?
I don't recall, ma'am.
The incident summary doesn't have any of Mr. Grismore's replies to the detective's follow-up questions. Is that correct?
I don't recall that either, ma'am.
On page 3, under incident summary, it says, in your words, I've elected to utilize a speech-to-text transcript of the narrative taken directly from Captain Grismore's statement during his internal affairs interview. So is this summary incident just Mr. Grismore's 6-page statement?
Yes, ma'am.
When did Mr. Grismore write this statement?
Did he write this statement? Is that what you said?
I asked, when did he write this 6-page statement?
I don't recall the date offhand, ma'am. But what I did was I took the narrative and actually used a software program to actually rewrite the narrative.
Do you know whether the 6-page statement was written the day of the event?
I don't remember that, ma'am.
Mr. Grismore wrote a separate use of force report on the day of the event. Did you review that report when coming together, when gathering his perspective of the event?
I did, ma'am, but I know lacked the detail I was looking for, so I focused on the complete narrative.
Okay. And you didn't think that any inconsistencies between one written report and the other written report would help contextualize his perspective?
I didn't note any glaring inconsistencies, and otherwise I probably would have mentioned them.
So the incident summary, the facts and circumstances that you based your opinion on is based entirely on the unquestioned, untested 6-page narrative written by Mr. Grismore at some unknown time after the use of force incident.
I'm going to object to the form of that question. No, it's cross-examination. Now, it assumes and characterizes things that have not been introduced in evidence.
Just repeat the question, please.
Sure, for the chair to consider?
Yes.
The question was, so the incident summary, the facts and circumstances that you based your opinion on were entirely based on the unquestioned, untested 6-page narrative written by Mr. Grismore on an unknown date after the incident.
That would be a mischaracterization, ma'am, simply because my opinions were based on what I watched on video as well. Both the body cam video, the booking room video. There are any number of things that weighed in on my synopsis of events.
You just don't mention any of that in your incident summary, is that right?
The incident summary is based entirely on, as you said, it's entirely on his narrative. But my conclusions are based on a totality of all that this case embodies. So we're talking two different things.
Okay, and when we get to your ultimate opinion, we'll try to break down where you pulled some of those pieces of information from. I want to take a step back. You mentioned that you have a master's in forensic psychology. Is that right?
Correct. That's correct, ma'am.
And then you've done a considerable amount of work around the human brain, the cognitive brain. Is that right?
Yes, ma'am. Perception and cognition. Yes, ma'am.
Could you explain to us what cognitive bias is?
Cognitive bias? Is that what you said, ma'am?
Yes. Yes.
Cognitive bias could be something that influences our actions based on our expectations. And I think it might apply to some extent in this case. I don't know if that's what you're looking for, but a cognitive bias can be expectations based on previous actions noted.
And to help the council understand, cognitive bias helps us filter all the information we're taking in all day. Is that right?
That's a more general and generic definition. Yes, ma'am.
Oh, we'll start there just so folks can track what we're talking about. So past experiences will help filter information. That's the idea of cognitive bias, correct?
Yes, when we're talking a law enforcement officer, we're talking a lot of things that create a cognitive bias. And we're looking at training, experience, we're talking about, so even beyond this particular scenario, our experiences throughout a long career might certainly lend themselves to a cognitive bias. Our training certainly lends itself towards a cognitive bias. And so we can talk about it in a generic sense, or we can talk about it as it pertains to this case. I can go either way if you'd like, ma'am.
Well, we'll get into that. There's a few different types of cognitive bias. One that we see most often is called confirmation bias. Is that right?
Yes, ma'am.
Could you explain what confirmation bias is?
It's a bias whereby you're looking for things to confirm what you already believe.
All right. So once I've decided something, I'm then filtering information to find facts that back up what I believe. Is that right?
That sounds right, ma'am.
In the video that Attorney Kaplan played during your direct, there were signs that Mr. Burrows was aggressive in the house. Is that right?
Yes, ma'am.
And under the idea of confirmation bias, if you see that sort of aggression, you're going to then later look for signs of aggression in that person, if you've decided they're an aggressive person, right?
It's going to heighten your level of vigilance, certainly. I think that's reasonable to assume.
Did you watch that entire video? Deputy Andelay's body camera?
I think I did, ma'am. I can't recall. Can't recall if I did. I watched quite a bit of video, and I'm assuming that I did, but I can't say that with certainty.
Attorney Kaplan started it at about 14 minutes in. And we see Mr. Burrows sitting and then standing up quickly, and then the scene deteriorates after that. Is that right?
That's what it appeared to look like to me, ma'am.
Do you recall from watching it, and if you don't, we can play it. Do you recall that there were moments beforehand where Mr. Burrows' behavior was going up and down? He was getting escalated and then he was calming down. Is that right?
That's the way it appeared, ma'am.
And then Deputy Andelay was able to get him to sit down multiple times. Is that correct?
It appeared that way, ma'am, yes.
And she was able to do that through talking with him, correct?
That looked like verbal redirection, yes, ma'am.
And so in watching that video, if my confirmation bias was that Mr. Burrows could be compliant, would I then later see signs of compliance, potentially where someone who was looking for aggression would not see?
Let me try to decipher what you're looking for here, ma'am. Could you reword that, please?
Sure. Let me break it down. If I watch that video and I see, oh, she got him to sit down multiple times, like he's actually being mostly compliant or sometimes compliant, that would be my confirmation bias, correct?
It could be. I'm just not sure where you're taking this, but go ahead.
That's okay. So if that's my perspective, confirmation bias would say I'm then looking for signs But if I see any signs of compliance, I'm like, yep, he's able to comply, like I'm giving evidence to that idea. That's the idea of confirmation bias, correct?
Well, ma'am, I think we have to delineate the behavior observed from pre-arrest to post-arrest. Because pre-arrest behavior was a bit more benign, actually a lot more benign. And the behavior you're alluding to is not what got him arrested. So we got to make that distinction right off the bat.
That's fine. So pre-arrest, he showed signs of compliance, like I can see that, right? I'm allowed to have that opinion, correct?
You can say that, but again, even with signs of compliance, we saw behavioral volatility. We saw behavior that was not modulated in a way that was reliable or could be predicted. One moment, for instance, he was seated and calm, and then he'd stand up and challenge one of the male officers. He seemed to feel obligated to want to challenge physically and actually physically threaten them, knock them out. So if compliance is measured in seconds, it's really doesn't mean much.
Okay, well, let's move away from the idea of compliance. We can see that his mood rises and falls throughout that video. Is that correct?
Again, pre-arrest versus post-arrest.
We'll start with pre-arrest.
Well, pre-arrest isn't really applicable here to me, as far as I'm concerned. The behavior that
That's
got
okay. I just want you to
assaultive behavior is what got him arrested. Once assaultive behavior began, it seemed to be fairly consistent throughout. He was never fully compliant, even when he was cuffed. He resisted efforts to getting him in the police car took a considerable effort. So again, delineate pre-arrest when he's a free man versus post-arrest when he's assaultive. That to me is one thing, the distinction we have to concede makes all the difference in the world in this case.
Okay. So post-arrest, after he's driven back to the department, what was his demeanor when he got out of the car?
I would characterize it as defiant intermittently. There were actions.
When he got out of the car at the department?
When he got out of the car, when he got into the booking areas, especially, that's the video that I think is most scrutinized. I saw a continuation of defiant behavior.
When he was walking from the car to the holding cell, you saw defiant behavior.
When he's walking to the car from the house, I saw defiant. I saw him kicking police cars. I heard him threatening officers. So defiant behavior was intermittent, but it existed throughout.
Throughout, from going to the house to getting in the police car, yes?
Yes, ma'am.
I'm asking, when he got to the department and he was taken out of the cruiser, what was his behavior going from the cruiser into the holding cell as an arrested person?
I still saw signs of agitation, behavioral agitation, and volatility.
We'll
And
move on from
and no
there.
time did I see his behavior stabilize. Let's put it that way.
When he quietly walked to the holding cell, you still saw that as defiant behavior?
I'm going with verbal and nonverbal communication. Defiance to me quite often is defined in nonverbal mannerisms, if you will.
Let's turn our attention to the Vermont use of force policy, the considerations that an officer needs to run through before applying force. And I know you mentioned some of this on direct, but on page 5, the second full paragraph states that a law enforcement officer, on the page. Are you on the page? Page 5.
Yes, ma'am, and you're breaking up a little bit. A law enforcement officer should use only force objectively reasonable. Is that the paragraph you're on?
Yes, I just wanted to make sure before I started reading that we were in the same place.
Okay, I'm there.
Okay. So law enforcement officer shall use only the force objectively reasonable, necessary, and proportional to effect an arrest. Is that right?
That's what it says.
Or to prevent an escape, correct? Is that right?
You're breaking. Did you ask a question, ma'am? You're breaking up still.
Apologize.
There are pauses in video.
So the
God, I'm sorry. I'm getting choppy video and choppy audio at times, so excuse me if I don't understand what you're saying.
That's okay. I can go slower, or if we need to log in or do something different on your end.
I shut down all the programs that are running in the background, so it shouldn't be something I can alleviate that easily. But go ahead, ma'am. What was your question? I'll try again.
Okay, and I'll reword it a little bit. The Vermont use of force policy explicitly says when we can use force, and one of those times would be to effect an arrest. Is that correct?
Yes, ma'am.
Another incident would be to prevent escape. Is that correct?
That's correct.
Or to overcome resistance of a person who police have a reasonable basis to believe has committed a crime. Is that right?
Yes, ma'am.
And then there's that last somewhat catch-all or any other lawful law enforcement objective, correct?
Yes, ma'am.
Okay. Is it fair to say that Sheriff Grismore's use of force was not during an arrest?
I'm sorry, could you repeat that, ma'am?
Is it fair to say that when Sheriff Grismore used force on Mr. Burrows, it was not to arrest him at that moment? He was already arrested. Is that right?
I would say that's correct.
It wasn't to prevent him from escaping, correct?
That's correct.
And there was no reasonable basis to believe that he was committing a crime, that the officer needed to overcome him.
I would say that's incorrect.
Because he was allegedly about to spit. Is that?
Yes, ma'am. I would characterize his behavior as, again, there was still active resistance, and the perception was that spitting was imminent, and so I would say that would have been a crime.
So that was the lawful objective that Officer Grismore was focused on when he committed his use of force?
I would say that seemed to be his primary concern or his primary focus.
Now, the use of force policy runs through a few different considerations that officers should think through. Your draft report also had a considerations section. Is that right?
Let me go there, ma'am. What page are you on, ma'am?
Page 10.
Okay.
In your considerations, you're focused on then Captain Grismore mitigating, lessening the possibility of being spat on. Is that right?
It's not so much getting spat on, ma'am. That's an occupational hazard. It's getting spat on in the face. Again, most times when spitters are spitting at a subject, they're spitting at his face, and that's unfortunately a pretty easy pathway for viral infections and any bloodborne pathogens that could be present in the mouth. So the spitting in the face issue is the primary concern.
Okay. So not spitting in general, but spitting in the face. Is that right?
Correct.
Okay. And so your considerations focused on creating standoff distance between the spitter and the officers. Is that right?
Some additional standoff distance, correct, ma'am.
And you note in your considerations that using a leg versus an arm would increase the distance by a few inches. Is that right?
That's a general conclusion I would reach. Yes, ma'am. If I see somebody's knuckles dragging on the ground, I might conclude otherwise, but.
Right, so you didn't tailor that specifically to Captain Grismore as far as his length of his arm, length of his leg.
General population, ma'am. My assumption is the legs are longer than the arms.
And that's fine. I'm just clarifying that that's a general assumption, not a specifically, you didn't specifically analyze Sheriff Grismore.
That's correct.
In your last consideration, is that preemptive action is objectively reasonable if a spitting assault is perceived as being imminent. Is that right?
Yes, ma'am.
On direct, you explained the difference between imminent threat and an immediate threat. Do you mind just explaining it again?
Sure. This is something that I was trained in years ago. New Jersey's Attorney General came out with guidelines back in the 90s when they first implemented an imminent threat standard. And the AG's office at that time said that an imminent threat isn't one that has to happen, and it's one that may happen, and there's no guarantee that it actually will happen. It's just a reasonable belief that something appears to be transpiring at that time. So it's a reasonable belief that an assault is about to happen. Perception is driven by understanding and of the context and behavioral cues that are exhibited. And it's largely driven by experience and training, and in this case, perhaps even Grismore's viewing the body cam video of what behavior transpired previously.
So what is an immediate threat?
Immediate threat is a threat that's already occurring. It's actually in the process. Again, the analogy I used earlier is you're actually dodging bullets, or somebody's lunging at you with a knife at fairly close distance. That would be an immediate threat, and it's often referred to as a dead man's standard.
So to use the situation that happened earlier at Mr. Burrow's home, when he stood up and postured his shoulders forward and clenched his fists, would that be an imminent threat or an immediate threat that he might?
It's going to depend on proximity. It's going to depend on whether there's any foot movement, any weight displacement. There are any number of things that we're looking at behaviorally. Again, for something to be objectively reasonable, again, and we apply this totality of circumstances model, which is admittedly kind of squishy. There's a lot of discretionary latitude built into it, which unfortunately is why we're here today. But if we look at clenching fists alone, that would not be actionable in most cases. If we look at clenching fists with weight displacement, leaning forward, maybe lunging forward, that's actionable. But again, there's a fine line between when this becomes imminent and when it becomes immediate. Depends on the proximity of the officer. It could depend on any number of things. Whether is there a chair or a table between the officer and the subject that's threatening him? There could be any number of other mitigating factors.
Okay, but the difference in time is that an imminent threat is pending, might happen, and an immediate threat is it's occurring. It's, as you said, bullets are flying, right?
Yes, ma'am.
In our Vermont use of force policy, our lethal use of force on page 10. Just tell me when you're on page 10.
Okay, I'm there, ma'am.
An officer is justified in using deadly force upon another person only when, based on the totality of the circumstances, such force is objectively reasonable and necessary to, one, defend against an imminent threat of death or serious bodily injury. Is that right?
Yes, ma'am.
So this is where you said earlier, an officer in a lethal force situation doesn't need to wait for the bullets to fly. They can act preemptively to ward off that threat. Is that right?
That's correct.
You can turn to page 6 in the use of force policy. In there. You're on page 6.
Yes, ma'am.
Under the section less lethal force, it says in determining whether a particular use of force is objectively reasonable, the officer must consider, and it says whether or not the subject poses an immediate physical threat to the officer or others. Is that correct?
That's what it says, but it also says that the officer should be judged within the totality of circumstances, whether or not what he did was justified, his response was justified. And again, we're looking at a totality issue here that there are a number of things, knowing he was a spitter, knowing he was a headbutter, there are a number of things that come into play within the totality of circumstances here.
And I appreciate that we're looking at this from a totality of the circumstances. But I'm asking, my question is, the threat that the use of force policy in Vermont requires for less than lethal force is an immediate physical threat, not an imminent threat. Is that correct?
Less lethal force is generally the realm of something that is not less than lethal, but it's less lethal. So that I'd have to have this defined a little bit more, with a little bit more specificity. Generally, when we talk about less lethal, we talk about something like beanbag rounds, and some people actually throw a taser in there, something that can inflict serious bodily injury, but is less likely to do so. Less than lethal is something like pepper spray or soft empty hand control, that sort of thing. So this leaves something open to an interpretation as far as I'm concerned.
Do you think it's open for interpretation that the policy specifically says immediate physical threat, not imminent?
Section 3 it pertains to less lethal force, not less than lethal, but less lethal force. It's something that a lot of people don't really delve into, but it's certainly a pertinent issue in this case.
As opposed to section 4, which is lethal force.
That's another issue altogether. There should be three different levels here: less than lethal, less lethal, and lethal.
Well, Vermont's policy only has two. We have lethal force and we have less lethal force. Those are the two categories that we have in Vermont.
And that's an omission, ma'am.
Given that omission, in your opinion, there is a clear difference in our policy in Vermont as to what threat level is necessary for an officer to be allowed to use force in a less lethal force situation. Is that right?
That's what this is, a less lethal force situation.
So an immediate physical threat is necessary under the Vermont use of force policy, not an imminent threat.
Again, a different entity altogether. For instance, this is an altogether hypothetical because it happened recently. You had a trooper shoot somebody on the roof of a dwelling with a beanbag, so-called beanbag round. That is considered less lethal. It's not less than lethal. It's considered less lethal force. And so this policy would apply to something like that. There was no immediate threat, and that level of force should probably not have been used in that given scenario. But to take that and apply that, again, something that was less lethal force to a scenario where we have less than lethal force used, to me, that's not applicable, or it's not appropriate altogether.
Nonetheless, it's the policy that we have in Vermont, correct?
Okay.
You may not agree with it, but it's what we have. If, and again, you don't agree, but if the standard is an immediate threat, can you take preemptive action before an immediate threat?
Again, that's something that should be judged objectively rather than subjectively. If the officer thought he had to do it for his own safety and the safety of others, that's something that he articulates it, then it's to me, it can be justified.
Okay, but inherent in the term immediate threat, the threat would need to occur for the officer to then be able to take action, correct?
If you're waiting for an immediate threat, you're waiting for literally spit coming towards your face. If that's your standard, that's what you're suggesting?
Asking the question, if the standard is an immediate threat, which means the threat's happening, then you need to wait, correct?
That's what you're
Until
suggesting.
the threat
That's not it's not something I would buy into, but that's apparently what you're suggesting.
Okay. Let's turn to your draft report, what you based the use of force reasonableness on. It's on page 10. It's titled Use of Force Reasonableness Based Upon. The first thing you based the reasonableness of Mr. Brismore's use of force was that he was vulnerable without a face shield. Is that correct?
That's correct.
And that he was at risk for possible viral transmission via Mr. Burroughs' saliva if Mr. Burroughs sat at him. Is that correct?
That's correct.
You also listed that he was at risk for exposure to bloodborne pathogens if Mr. Burroughs was experiencing any bleeding in the gums. Is that right?
Yes, ma'am. That's difficult to discern. I would work from the my working assumption would be that somebody has a gum issue rather than assume not. Given all the recent paranoia with face masks, N95 masks, face shields, goggles, I work at a hospital where paranoia exists as I've never seen it before with regard to the exchange of, possibly viral droplets in the air. We're talking about dodging spit. So yes, ma'am, I clearly believe in what I posited in this report.
Yep, understood. Was there any evidence in the materials that you reviewed that Mr. Burroughs' mouth was bleeding in any way?
No, ma'am. Like I said, you work from the assumption. That's what we do every day at the hospital that I work at. We work from the assumption that we're dealing with carriers that if they cough, they're going to spread it to others that aren't protected.
So the reasonableness threat of a bloodborne pathogen is purely theoretical in here. You're assuming that it's possible, but there was no evidence of that.
Well, let's take a step back. The spitting itself is an assault. To what degree the assault is even more egregious by the spreading of either some type of virus or a bloodborne pathogen, that's a separate issue altogether. But the assault is the spitting in itself is an assault. So anything that transpires from that is certainly something we probably won't ascertain until the scenario is over. And unfortunately, that's too late to protect the officers involved.
I hear what you're saying, but I just want to clarify that this is in theory then, that it's a possibility that the spit could contain a viral transmission or a bloodborne pathogen, but there was no evidence of that in this case.
There was outward evidence, ma'am. So No, there's no way I could tell. There's no way I would know, and there's no way the officer could know.
No, understood. Just clarifying that you wouldn't know that.
He wouldn't know that. If someone points a
So
gun
as
at
you,
would you anticipate that that gun is loaded? Would you act as if that gun were loaded? Or would you rather assume the gun was unloaded? We're working from the same premise from an officer safety standpoint. Assumptions should be made in ways that enhance occupational safety and not the reverse.
well, from our prior discussion, I don't think we're going to agree on that, since there are two different standards for lethal force and less lethal force in Vermont. But let's move on to the spitting, because that is the, as you said, it was Mr. Grismer's priority, and it is one of the key pieces that you base the reasonableness of his actions on. For your draft report and your testimony earlier, the physical threat to Sheriff Grismore was this potential assault of being spat on. Is that correct?
That's correct.
When Officer Grismore was standing in the doorway observing the other officers working with Mr. Burrows, did Mr. Burrows pose a threat to Sheriff Grismore when he was in the doorway?
Did he pose a threat when Officer Grismore was in the door? Captain Grismore was in the doorway. Not to my recollection, ma'am.
Prior to Mr. Grismore's first, I'll call it a kick, you called it a foot push. Is there any evidence that
An expert witness called it a foot push, ma'am.
we'll use your term then? Oh, sorry, you said my expert witness called it that. So prior to Mr. Grismore's first use of force, using his foot, is there any evidence that there was an immediate physical threat to Sheriff Grismore?
At this juncture, ma'am, that you're taking fully out of context, everything has to do with proximity and involvement. So as Captain Grismore had a standoff distance from Burrows, he wasn't at risk of any spitting or potential headbutting or anything else. Once he interceded on behalf of his deputies, he placed himself at additional risk in doing so.
Correct. So prior to the first kick, he personally was not in danger, but after he used force, he was then in that proximate range where he could get spat on potentially. Is that right?
Yes, ma'am.
When assessing whether Mr. Grismore's actions were objectively reasonable, given the totality of the circumstances, did you weigh the seriousness of the offense the officer believed the subject was involved in?
Did I weigh the seriousness of what, ma'am? I'm sorry? Of the
Did you weigh
offense?
the seriousness of, yeah,
So you're asking me if I weighed the seriousness of the assault of Burrows' assault on the officers, the arresting officers? Yes, ma'am, I did.
yes, was that one of the, okay,
I'm
so that's one of the
Captain,
factors.
I'm assuming Captain Grismore did too if he reviewed the body cam video.
Did you weigh the degree of that threat that it posed to then Captain Grismore?
Yes, ma'am. I did separately that once he got within proximity and he anticipated the fact that resistance didn't end, the fact that we still had some degree of active resistance on the part of Burroughs when he was brought into the booking area. And once Captain Grismore intervened, he put himself at risk, really to the benefit of the officers and the other officers involved. He actually, by assisting them, he put himself at greater risk.
And the threat that Mr. Burroughs posed at this time was that he could spit. Is that right?
Spit and or headbutt. He wasn't fully restraint is something that's kind of subjective, ma'am. We talk about people being restrained, and as I mentioned earlier, there have been documented cases where people who were handcuffed have actually disarmed officers and shot them with their own gun. So this level of restraint that we saw took away quite a few of Burroughs' options, but it did not completely make him it wasn't something that defanged him completely.
Okay, so he could spit or he could headbutt. He couldn't use his arms though, correct?
He could have used his elbows. I've seen people throw a pretty good elbow when handcuffed. So, I mean, again, the longer you've been on the job, the more you've probably witnessed things go wrong, things that you hadn't anticipated. And this is the reason why his level of experience should be weighed very differently from the officers, the two arresting officers involved who had very little experience on the street.
In the holding cell, was there any evidence that he was trying to hit somebody with his elbow?
There was, again, there's still a level of agitation that was a concern. There's still a level of defiance, of open defiance that was a concern. Generally, that degree of agitation and defiance precipitates or precedes physical actions that are, you're trying to read and anticipate what type of physical actions you might encounter, and his behavior was indicative of a pre-threat behavior.
Pre-threat, but there was never any immediate threat. There was never any like throw of the elbow or rearing his head back to headbutt someone. Is that correct?
Again, if we're talking the totality of circumstances model, any foreknowledge of the manner in which he assaulted two of the deputies involved in the arrest, that would add to his expectation of continued violence. I think, and reasonably so.
I believe on direct, your opinion is that Mr. Burroughs was actively resisting in the holding cell. Is that correct?
Sporadically, yes, ma'am.
And that's based on him physically moving around when the officers did not want him moving around. Is that right?
Yes, ma'am. They tried to get him to stay seated, and he would not. This was not somebody that really could have been left unsupervised for any length of time, at least from the behavior I saw and the behavior he exhibited, which could have been self-injurious as well.
So his behavior when told to sit down was to remain standing. Is that right?
Well, he kept getting up, and that was part of the problem. He became more problematic as he stood up.
Right. he stood up and he moved around a little bit. Is that right?
He moved around a little bit. He was, again, he expressed some degree of defiance, and any posturing that seemed to be indicative of a pre-spitting, that is, someone that's actually looks as if they're puckering up and gathering saliva to spit. It's fairly obvious to somebody that's been spat at before.
And the council has seen the video, so we'll let them see whether they see the same thing. So it's your testimony that Mr. Burrows was actively resisting before Sheriff Grismore used force the first time. Is that right?
I would call it yes, because it certainly wasn't passive resistance. He's on his feet, he's moving around, he was defiant. So I would say that we've crossed the threshold of passive resistance to, let's put it this way, had the cuffs not been on, we probably would have seen much more aggressive behavior than what we saw. So the cuffs were an inhibitor, but they did not completely eliminate the possibility of physical menace.
And it's your testimony that he was actively resisting prior to the second kick, that he stood right back up after the first kick. Is that right?
Again, the nonverbals that I saw, the physical posturing that I saw was a concern. They're pre-threat indicators that concern me. And I would characterize it not as a model of passive resistance, but one that just crosses the threshold of active resistance.
In reviewing the Vermont's use of force policy, what is the role of de-escalation in less than lethal force situations?
The role of de-escalation. De-escalation
Yes.
is aimed at actually diminishing the possibility that the more drastic means or methods will have to be utilized. So you're generally using verbal engagement to try to bring about some degree of emotional compliance.
And doesn't the Vermont use of force policy have an affirmative duty to attempt de-escalation tactics prior to using force if it's safe to do so?
I'd say that was done throughout the conflict with Burrows, to be honest with you, from on site and in the cell itself, in the holding area itself. I'd say that there were numerous attempts. Probably, I couldn't even begin to count how many attempts there were to get him to become more compliant.
Numerous attempts by the other two deputies, correct?
Yes, but even Captain Grismore's verbal commands which were much more emphatic, were pretty much ignored.
And that verbal command happened after the first kick, correct?
Verbal commands, what after the first kick, ma'am? It wasn't a kick, ma'am, it was a push. But
that verbal command occurred after the first use of force, correct?
did they continue? Is that what you're asking?
No, you mentioned that Sheriff Grismore did give a verbal command, and I asked, didn't that occur after the first use of force?
Ma'am, and my recollection is there were verbal commands given continuously throughout this encounter by all parties involved.
my question was for Sheriff Grismore. That his verbal command was issued after the first use of force. Is that correct?
I do remember that. I don't remember sequentially the how often commands were given by Captain Grismore.
Do you recall if Sheriff Grismore identified himself as a police officer before engaging in his use of force?
I don't recall that, man, but he's in custody. He's in a lockup. I think a reasonable person would conclude that you're being confronted by law enforcement officers, whether they're in plain clothes or not.
So Mr. Burrow should have assumed that he was a police officer. Did Sheriff Grismore issue a warning before applying force?
There were warnings given throughout. There was any number of attempts to moderate Mr. Burrow's behavior that were failures. The only time I saw Mr. Burrows actually become more compliant is after the second foot push and the hood was put on his head. That's about the only time I saw any attenuation of his outward aggression.
My question was, did Sheriff Grismore did he issue a warning before applying force?
Before the first push or the second?
Before the first push, did he provide a warning?
I can't say with any certainty, ma'am.
Telling someone just to sit down, a warning?
Yes, ma'am, that would be a warning.
Isn't that a command?
Well, you could call it a command depending on how emphatic it was, but it's a command or a warning, and take your pick. It just depends on, again, the second push was much more emphatic, and that seemed to elicit a stronger verbal command.
Isn't a warning providing to somebody information? If you don't sit down, I'm going to blank. Like, isn't that a warning?
Again, we're delving into the domain of subjectivity, ma'am, and I'd have to. The difference between a warning and a command sometimes is indistinguishable to some extent. Because this is one, if we look at this as one continuous event from the time Burrows assaulted the officers to the actual confrontation in the lockup area. We can't take any of this out of context, which I'm afraid that seems to be what I'm hearing here, that there's a very concerted effort to take actions out of context, and that's not what Graham v. Connor warns about. It warns about the problem with applying 20/20 hindsight to an officer's actions, and I think that's apparently what we're doing right now.
Well, what we're doing is breaking down what occurred in that room, and then the council will be able to take all this information together and decide on the totality of the circumstances. The Vermont use of force policy states that an officer, if able, if safe, provide a warning and time for the person to comply. So in that context, a warning is telling someone what will happen if you don't do X. Is that correct?
That would be a warning, ma'am, but I think that's a reasonable definition of a warning.
That's all. And we did not hear Sheriff Grismore provide a warning before his use of force.
My feeling on that, ma'am, is he's not obligated to give a warning. If he sees objectionable behavior, assaultive behavior, resistant, defiant behavior, I don't think he's obligated to give a warning.
When a person is impaired by alcohol, the use of force policy in Vermont requires an officer to take that information into account to determine the amount of force used. Is that correct?
Yes, ma'am, I'm looking at that. That works both ways.
Yep, I'm just asking if that's part of the use of force policy, that an inebriated person, you're going to just factor that into your assessment, correct?
Yes, ma'am, it's a double-edged sword. It cuts both ways.
In a non-lethal force situation, meaning that the officer is not in danger of death or serious bodily injury, officers can often use time to their advantage. Is that correct?
They have time to their advantage. Is that what you said, ma'am?
They can use time as a tool, as a tactic to their advantage, correct?
Well, this is again a subjective measure that you're applying after the fact.
I'm not asking whether there was, how the time was used in this case. I'm just asking, isn't that a tool for the police to use in certain situations? That they can slow things down, that they can take some time?
That's an assumption that I'm not altogether comfortable with, ma'am.
When you took your latest use of force legally justified, but it was avoidable, excuse me. One of the segments was on slowing things down can be your most powerful tactic. Did you take issue with that in your training?
I think that's taken out of context too. Slowing things down in some scenarios certainly makes sense. It depends on to what degree you're actually able to slow things down.
When you were listening to a few weeks ago when Sheriff Grismore was testifying, he felt that the deputies at a certain point had lost control of Mr. Burrows, and that's when Sheriff Grismore decided that he needed to step in. Do you recall that testimony?
I believe so, ma'am, yes.
And we estimated that between the moment he felt like the deputies had lost control, it was about 3 to 4 seconds before Sheriff Grismore's foot was on Mr. Burrows. Do you recall that?
I'm not sure of the actual timeline, ma'am, but I would say that's pretty close.
You. Do you think it was objectively reasonable that he responded that quickly to using force, given the facts and circumstances in front of him?
Given the facts and circumstances, the totality of facts and circumstances as he knew them, yes, ma'am.
That he couldn't give his deputies any more time to continue to work with Mr. Burrows?
He could have given them more time. What degree of success they've had in the time they've had. And I would say based on what he probably saw, I mean, again, this is an assumption on my part. He probably wasn't overly impressed by what he saw.
Wasn't really impressed by what he saw.
Going back to the spitting, in your draft report on page 11, your last, I believe the way it's under the reasonableness of Sheriff Grismore's actions, that it was reasonably objective for Sheriff Grismore to use force because spitting is a simple assault, a misdemeanor. Is that correct?
You're on page 11, you said, ma'am?
You're on page 11, you said, ma'am?
Yes, sir.
The first sentence of spitting.
The first sentence of spitting is simple.
Is that what you-
Yes, on page 11, the beginning says the act of spitting on someone is a deliberate act, and if the victim is reasonably fearful of being harmed, it should be considered an assault under Vermont law.
Yes, ma'am.
Yes, ma'am.
Are you aware that in Vermont, simple assault requires a bodily injury?
It requires a bodily injury
It requires a bodily injury for simple assault?
Yeah, the basic run-of-the-mill simple assault.
Is that codified,
The-
ma'am?
one of the elements. Sorry.
Bodily injury where I come from is
Bodily injury where I come from is
pushing a threshold of aggravated assault.
pushing a threshold of aggravated assault.
You know, in New Hampshire, right, you have that, it's impermissible contact, right? That either there's an injury or impermissible contact for simple assault.
Yes, but I'm wondering where you're going with this, ma'am. What is it you're looking for?
Oh, well, just in New Hampshire, I believe, just spitting on someone, just the contact of the spit alone is enough to charge a simple assault, correct?
That's my understanding.
That's my understanding.
In Vermont, you actually can't charge simple assault unless the person has a bodily injury from being spat on. Did you know that?
Is that codified, ma'am, or is that just a, that's something that's an interpretation that you, I've not seen that in writing.
Our simple assault statute reads, a person is guilty of simple assault if he or she, one, attempts to cause or purposely, knowingly, or recklessly causes bodily injury to another. We then have two other subsections, but they have to do with negligent injury with deadly weapon and physical menace, that sort of thing. But sort of the straight, I touch you and I injure you. In Vermont, we require bodily injury. We don't have the impermissible contact that New Hampshire has. Were you aware of that?
Well, no, but let's take and run with that.
Well, no, but let's take and run with that.
So if somebody spits in my face and they've got MRSA and they spit in my face, I might not know they have MRSA. They spit in my face. Is that bodily harm if I contract MRSA? If I get it in my eyes? I would characterize that as bodily harm.
Yeah, the definition for bodily injury is that you have to suffer some sort of pain or injury or illness. So we actually couldn't charge a simple assault unless that person contracted an illness. Then you could prove injury.
Your Honor,
I'm happy to move on. Yeah. The reason why I bring this up is you cited Title 13, Section 1028, which is assault of protected professionals, which is a misdemeanor in the state of Vermont. Were you aware that one of the reasons why this statute was created is because you don't need to show an injury if you spit or throw any other bodily fluid at a protected professional?
I would object at this point to this line of questioning has been very much Ms. McManus testifying. And asking the witness to ratify her testimony rather than asking this witness for his testimony.
So you're asking to put a halt to this by testimony about statutory requirements of sexual assault in Vermont?
Well, I'm specifically objecting to the form of these questions, which truly are testimonial and not related to the specific evidence that's been produced in the case. And it's for that reason.
Cross-examination, yes, or no, that's reasons. Testifying with the question, there's a lot of right, your point is that we should be allowing tax already.
That is fine. Thank you. In your draft report, the second sentence under spitting as a simple assault, you state spitting at a law enforcement officer may not in itself be grounds for hard, empty hand control techniques, but one can readily argue that if an officer felt endangered by the act and responded physically to that perceived threat, his actions may be deemed objectively reasonable when viewed within the totality of the circumstances. Is that still accurate?
Yes, ma'am.
So if an officer did not feel endangered by the act of spitting, would that then nullify hard empty-hand control techniques being justified?
If we got multiple officers on the scene and one is in close proximity to the spitter, we could have several different perspectives on the same event, ma'am. I'm not sure where you're going with this. If I'm within 2 or 3 feet of being spat upon and the other officers are 5 or 6 feet away and not directly in somebody's face, then that will certainly have a great bearing, I think a substantial bearing on one's perception.
So, in your opinion, the officer needs to feel endangered by this act of spitting, in order for hard empty-hand control techniques to be reasonable. Is that right?
Yes, ma'am.
I only have a few more questions. So ultimately in this draft report, and I believe it was in your direct testimony as well, you based some of, Sheriff Grismore's knowledge of Mr. Burroughs' past aggressive behavior was part of your analysis for his force being reasonable. Is that correct?
That's correct.
That's correct.
And so when you gave the opinion at the end of that first full paragraph, given this knowledge, the knowledge that he had of the past, Mr. Burroughs' past behavior, and the erratic and assaultive behaviors exhibited at the time, the totality of the circumstances suggest that his restrained preemptive actions were warranted at that time. That's still your opinion?
Yeah. ma'am.
So part of your opinion is contingent on him having that past knowledge, is that right?
Well, we're talking about contemporaneous knowledge, ma'am. This is all one event. We look at this. This isn't like his knowledge of his past behavior was of something he did 6 months or a year ago, something that he had just done within the last 10, 15 minutes. So there's a continuum here, and it's a very short continuum with regard to what happened on the front end that caused the arrest and what happened on the back end that resulted in the actions of Captain Grismore. So yes, I would say that had a reasonable bearing on his reasoning and his ultimate actions.
Captain Grismore had not heard about the arrest at the house, if he had not watched that video of the arrest, would his actions have been reasonable responding to just the behavior he saw in the holding cell?
So you're throwing a hypothetical at me. If we eliminate one of the most important variables, would his actions have still been justified? Am I comfortable in weighing in on that, ma'am?
That's fine. So that past knowledge is one of the most important variables in your analysis.
Again, this so-called past knowledge is contemporaneous. It's not something far removed from what happened in the jail, in the booking area. It's something that happened literally minutes before. So it's a continuation of behavior already exhibited. I think that's an important thing to actually embrace in this case.
Well said.
I have a relatively short redirect,
What does that mean?
10 minutes. Thanks. Mr. Ravini, you were asked questions about the less lethal force provisions in the Vermont use of force policy on page 6 of 33 of the policy. Do you still have that in front of you?
I do.
In the less lethal force section 3, the policy actually reads, in determining whether a particular use of force is objectively reasonable, the officer must consider, and it lists A, the seriousness of the offense the officer believes the subject is involved in, B, whether or not the subject poses an immediate physical threat to the officer or others, C, the degree of threat posed by the subject, D, whether the subject is actively resisting or attempting to evade arrest, detention by flight, and E, whether the totality of the circumstances justifies the officer's response. Now, what this policy says is the officer must consider all of these things. Does this policy require that there must be an immediate physical threat to the officer or others in order for an officer to use force?
I don't see that specified, sir.
Is this, would it be fair to say that all this does is list a series of factors the officer is required to at least consider before using force?
That would be my interpretation.
And if we would go back and look at page 4 of 33, which is within the definition of objectively reasonable, the defined terms in the policy, which continues on to page 4. Those are the factors that a reviewer considers in assessing whether force is objectively reasonable. Would you agree with that?
Yes, simply because a lot of this, this laundry list approach to objective reasonableness is something that generally officers don't have a checklist in their mind when they're involved in a scenario like this. This looks like something applied after the fact.
Now, what this definition in the provision of the objectively reasonable definition says factors to be considered in determining the objective reasonableness of force include but are not limited to. Now,
Yes.
from a police practices point of view, what is the include but are not limited to language in this mean?
It suggests to me that there's some. So how we interpret the seriousness of the crime or suspected offense, that's is the fact that deputies were actually assaulted, in the minutes leading up to this event. Does that weigh in on the seriousness of the threat involved? I think it does. The level of threat or resistance that was noted from that point on the way to the car and in the booking area. I mean, there are any number of things that fall into this set of guidelines, for sure.
You were asked questions about imminent versus immediate, the distinction between the standard for using lethal force versus the standard for using what's described as less lethal force. Or is there anything in this policy that you have read which would create a standard under which a police officer in Vermont must be confronted with an immediate threat in order to use force?
I've not seen that.
I've not seen that.
Looks like the prevailing standard really is an imminent threat standard.
Thank you. And if you would look on page 5 of the Vermont use of force policy, page 5 of 33, section dealing with de-escalation techniques.
You're on page 5.
5 of 33.
All right, I see the paragraph you're alluding to, okay.
And the third full paragraph begins with, in bold, when possible, officers shall use de-escalation techniques. Now, from a police practices point of view, what does it mean that when possible, officers shall use de-escalation techniques?
Well, it suggests to me that the behavior of the arrestee is what's possible and what isn't.
Is what we see on page 5 of 33 of this policy within the Vermont use of force policy, a requirement that an officer must use a de-escalation technique prior to using force?
I don't see that. They're embedding this as a series of considerations.
Now, when an officer, as in this case with Captain Grismore, is involved with other officers involved with the same subject, does the officer who uses force have to be the same officer who tries the de-escalation techniques?
No. No. And this is a fairly complex scenario, given everything that preceded this booking room incident. So we had officers that tried to de-escalate throughout the front end of this scenario, this incident. And if we embody that or include that in our totality of circumstances model, we're looking at, I think, the fact that we're going to have 2 or 3 different officers with different perspectives on what was necessary and what wasn't. There's going to be some deviation anyway. And I think for one officer to try to de-escalate while another's worrying about the physical aspects of this scenario, that's pretty common.
Okay, thank you. Those are all the questions I have.
And the defense rest.
Yes.
Lee, you have reserved the right to call your news process.
I did reserve that right. I'm not going to be recalled. There's no rebuttal.
Now, were a couple of documents, I didn't hear that they were had an exhibit number, nor I'm thinking of the draft report or descriptor, but those were not marked as exhibits. I don't really know where they are for the commission.
That's correct.
Then the evidence is closed. You've been going a long time without a break. My suggestion is that we break about 45 minutes for lunch. And then each side will have 10 minutes to summarize to the council your arguments on what action council should be taken. And at that time, we will clear this room and council on different things will reconvene private setting to do it. That makes sense?
Yes.
It might be slightly longer than 10 minutes to sum up all of what we've heard here. We'll try to keep it brief.
12 and a half. All right, brief. Thank you. We break for lunch.
Thank you.